Locke on Religious Toleration, Lecture 1. So, in the previous lectures, we have gone through most of the basic political principles of the American founding. We've gone through the inherited principles from England concerning constitutionalism, rule of law, legally protected individual rights. We have looked at Tocqueville's description of the Puritans and more generally the colonial experience with self-government, that even though the colonists came from a society that was aristocratic and monarchical, in the New World they were more or less left alone. And in the New World, they did not reestablish any kind of aristocratic order, but rather developed self-governing communities where more or less ordinary people were formed part of the sovereign people, and where the government was accountable to the people, and where you basically had a self-governing community that was imbued also, especially in the Puritan states, with an intense religiosity, which led to what Tocqueville describes as this particular American combination of the spirit of liberty and the spirit of religion. That in the areas of religion and of morality, Americans are quite dogmatic, whereas in the areas concerning politics and how to structure and run government, Americans are actually very innovative compared to everybody else around them at the time. And of course, before that, we looked at Locke's political philosophy, where we were introduced to some basic concepts such as natural equality, equal natural rights, the need for the consent of the governed in the form of a social compact in order to establish government, the right to rebellion, and also some of the principles of, especially of limited government, that the legislature has to rule through law, that you cannot have arbitrary government, and also the other protection against arbitrary government, which takes the form of the separation of powers. So we've covered all of that already. Today we get to another element of the American founding that is important and that also in some ways is derived from or informed by Locke, and that concerns the principle of religious liberty. The main individual rights that we had been talking about before with Locke were the rights to life, liberty, and property. And those are all very important, but especially for the founders, the right to religious liberty was considered equally, if not more important, freedom of religion. And the American founding and the founders' understanding of religious liberty is very much informed by Locke, but it is not identical to Locke's. But it's helpful to start by reading Locke's famous letter concerning toleration, which is, in the history of philosophy, perhaps still the most famous defense of what we would call religious liberty. And in the letter concerning toleration, Locke basically defends the claim that in political society, the state, or the magistrate, as he calls it, what we would say is the government, that the government does not have the right to command subjects to believe and worship in any particular way, nor does it have the right directly to forbid subjects or citizens from believing and worshiping in any particular way. That the only real limit is that citizens are not allowed to profess religious opinions or engage in religious practices that break the law. Sort of general laws protecting life, liberty, and property. But as long as you are not breaking the law or advocating breaking the law, subjects should be free to believe and worship as they see fit. And that captures a lot of the American understanding of religious liberty, although, as I said, that understanding goes a little bit further. So now I want to start by mentioning that in our Constitution, religious liberty is enshrined in the First Amendment, where it says Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof, or words to that effect. And when you look at the language of the First Amendment, you see that religious liberty has really two elements to it, as I see it. Again, this is not my specialty, but this is the way that I think is helpful to think about it. The first aspect of religious liberty is what I call free exercise, the free exercise of religion. And free exercise of religion means the right of individuals to profess religious beliefs and worship in accordance with those beliefs without being harmed or penalized for doing so by others or by the state. And of course, without being prohibited to do so. So this is sort of like what we mean when we say freedom of conscience. You have the right to form your own religious beliefs. You have the right to express your religious beliefs. You have the right to worship in accordance with your religious beliefs. And neither the government nor your fellow citizens have the right to try to prevent you from professing or worshiping in accordance with your conscience, or harming you because of your religious beliefs or worship. So that's free exercise. And free exercise is roughly what Locke is defending in the letter concerning toleration. Although I would say that the American understanding of the free exercise of religion is actually more extensive than what Locke defends. And we'll see that a few lectures from now when we look at some founding documents about religious liberty. But alongside free exercise, there's a second element of freedom of religion. And this is what I call non-establishment. So as you recall, the First Amendment begins by saying, Congress shall make no law respecting an establishment of religion. An establishment of religion, that's a phrase that at the time of the founding referred to a situation where the government actively endorsed and supported and perhaps even ran a church. So where you would actually have a church that was officially established as the state church. And this is something that exists, all around the world to this day. I mean, England has an established church. The Anglican Church is the established church in England. And what that means is that tax money collected from the Britons some of that tax money goes to support the Anglican Church, to pay for the maintenance of buildings, to pay employees, and so on. So public money is used to support the Anglican Church, and also the government has basically final authority over who runs the church. And of course, the Queen, or the monarch, but currently the Queen, is officially the head of the Anglican Church. So that's an established church. And I wanted to mention that you can have an established church and still have free exercise. Sometimes people conflate free exercise and non-establishment. So I want to make sure this is clear. Because in England or in Britain, there is an established church. The Anglican Church is the established church. But there is also free exercise. That if you go to England, you don't have to be an Anglican. You're not commanded to be an Anglican and forbidden to be anything else. You can be pretty much whatever religion you want to be. You can form a church, right? You can be Catholic in England. You can be a Calvinist in England. You can be a Buddhist, Muslim, Hindu, anything. So there's free exercise, but there is one church, the Anglican Church, that gets special support from the public authorities, and that the public authorities are involved in running. That's what it means to have an established church. At the time of the founding, so at the time that the Constitution was adopted, there were several states that actually had established churches. For example, in Massachusetts, where the Congregationalist Church was the established church of the state of Massachusetts. So in the United States, there was a practice of establishment, not in every state. There were many states that did not have any official church. But what you tended to find by the time of the founding is that whether you're dealing with a state where there was an established church or states that did not have an established church, there's still a general agreement regarding free exercise. All right, so you didn't, even in the states that had established churches, it wasn't that you had to be a member of that church. You could believe in worship otherwise. But so that's why I'm saying these are two different principles, free exercise and non-establishment. And so what the principle of non-establishment is the notion that there should be a separation of political authority and church authority. Sometimes people talk about a wall of separation between church and state. That's taken from a letter that Thomas Jefferson wrote. That's not, even though that's even been invoked by the Supreme Court, that's not really the right way to describe how the founders saw it, simply because the notion of a wall of separation is ambiguous and can be interpreted in different ways. So I'm going to try to make sure you have a more precise understanding of how the founders thought of the separation of church and state. But so Non-establishment means a separation of political authority from church authority. And in particular, that means that the state should not give money or preferential treatment to any particular religious sect or have any role in choosing religious authorities or in setting up the laws that govern particular churches. So basically, the political authorities should not govern or materially support specific official religious establishments. That's what non-establishment means. Now, as should be clear from the example I just gave a moment ago, non-establishment was not a universally agreed upon principle at the time of the founding, because some states did not have an established church and some states did have established churches. But with the adoption of the Constitution in 1789 at the national level, at the federal level, the First Amendment made clear that whether any particular state wanted to have an established church or not, it would nonetheless be the case that there would be no national church. There would be no official church of the United States of America. Congress shall make no law respecting an establishment of religion. And that weird phrasing, Congress shall make no law respecting an establishment of religion, it seems unnecessarily long, right? Why don't you just say Congress shall not establish a religion? Well, the reason why they chose the language they did, Congress shall make no law respecting an establishment of religion, is that what that says is the Congress of the United States, the national Congress, federal Congress, shall not establish a national church, nor shall it make any laws disestablishing the state churches. So originally, the First Amendment was understood to protect the right of state governments to have an established church if they wanted it, or not to if they didn't. But the idea is the federal government would stay out of that. Whether any given state had an established church or not was up to the people of that state. That was the original understanding. That is not how the Supreme Court interprets it nowadays. Over the course of the 20th century, the Supreme Court in significant ways altered the way that it interpreted the First Amendment, and also began to interpret the First Amendment as applying not only to the federal government, but to the state governments. So we have the current kind of constitutional regime regarding religious liberty is more complicated than at the time of the founding, but we're focused on the founding. So religious freedom, I should mention, though, that by the 1830s, pretty much every state had disestablished their churches. So by the end of the 1830s in the United States, non-establishment, but maybe somewhat outside of Utah later on, it was more or less a consensus position within the United States that religious liberty required both free exercise and non-establishment. Now, the reading from Locke that we're doing for today is specifically concerned with free exercise. Locke is not challenging the ability of political authorities to have established churches. He is merely arguing that whether you have an established church or not, it is the case that citizens have a right to, more or less a right to the free exercise of religion, that people should be allowed to profess and worship in accordance with their beliefs, so long as that doesn't lead to them doing anything illegal. And this is important because it had been a rather traditional opinion that the responsibility of the king or of the government included not only looking after the temporal welfare of subjects and the common good of society, so things like protecting people from harm and promoting prosperity and all of that. There is the temporal well-being, and the government was certainly responsible for that, but the belief was that the government was also responsible to some degree for the eternal welfare of subjects. At least in the sense, not that the government should have direct religious authority, because, until the Reformation, the church was its own institution, although it got complicated at times. But the basic idea is that the prince, or the government, or the magistrate, as Locke calls them, has a duty to ensure that true religion is taught in their realm and that false religion is suppressed. And the idea is that this is for the good of the governed, that a king that did not care about the eternal welfare or salvation of his subjects was a bad king. So you've got to look out for the temporal welfare, but also the eternal welfare by making sure that true religion is taught and false religion is suppressed. And in the Middle Ages, this, involved the persecution of heresy and things like that. But this idea that the government should be involved in the religious beliefs and practices of the community became an explosive belief once the Protestant Reformation got going in the 1500s, because all of a sudden you started to have very deep divisions within Christendom over what the true church was. So you have Catholics and Protestants of various stripes all disagreeing over who the true Christian church was, but all of them believing that the government ought to promote the true church and suppress the false one. And this led obviously to waves of religious persecution, religious war, a lot of destruction. You learn about that in your history classes. Because the idea was, well, we're the true church, so we should do what we can to seize power and to suppress our religious opponents. So the belief that the government should promote true religion was one of the things that actually fueled the Civil War and wars and conflicts around the time of the Reformation. And Locke's letter concerning toleration, which comes, quite a bit later, 1688 or so, argues that this is misguided. That a lot of this conflict, a lot of this religious persecution, was based on a false premise, namely that the government should be actively concerned with the salvation of your soul. He will argue, no, the government should not be, in fact, cannot really be. And so part of the goal here is to diffuse religious tension within society. Different religious sects should tolerate one another, and the government should tolerate the existence of many religious sects. Now, there is a question how extensive this toleration goes, because especially if you read the entire letter concerning toleration, Locke seems to make it pretty clear that he does not actually think that Catholics should be tolerated. It would seem to apply primarily to different Protestant groups, arguing that the different Protestant sects should tolerate one another. But then there are other places where he speaks as though what he's saying actually applies to not only to various kinds of Christianity, but even includes toleration of Judaism, toleration of Islam, and even toleration of paganism. So it's a little bit unclear. I mean, I think Locke himself has a pretty clear idea in his mind what he's doing, but reading the letter concerning toleration, oftentimes you think you understand something and you realize the point is a little bit more complex than you thought, and that's just the way it is. So I'm going to end this lecture there. This is this is an introductory lecture. And in the next lecture, I'll begin to get to the content of the letter concerning toleration.